So Adrien has the very difficult task to be standing between us and the cocktail, but also a very difficult task, which is to talk about the implication of the recent regulation on data protection for the blockchain ecosystem.
Thank you. I guess we are learning all together the meaning of liquid trust right now. As the room gets warmer and warmer and our body turns into water, I'll try to be the last, and I wish, and I hope not the least, speaker to give you a solid thought on those difficult subjects. A lot of confusion is being around the term of GDPR, which stands for General Data Protection Regulation, and there's also a lot of confusion when we talk about blockchain. And here am I in front of you, trying to talk to you about both. In English, it's going to be amazing. So basically, a lot of people are trying or are asking themselves if their blockchain project is GDPR compliant. I'll try to give you today a prime definition of the key principles and in this regulation, and I'll also tackle the obligation when you're a data controller or a data processor, the rights you have as a data subject, and I will try to see how we can make this happen. But before that, just a quick, just a simple question. A lot of people say, yeah, blockchain is not GDPR compliant, it's not going to work. If you come to think about big data, it's actually not already GDPR compliant. GDPR is a European regulation that is that came into force last May 25th, 2018, and is since it's a regulation and not a directive, it doesn't have to be transposed into different EU member states. It's directly applicable, and pretty much the aim of this regulation is to, as the previous 95 directive, it's striving to promote the circulation of data within the EU, and at the same time to protect the rights and individuals of data subjects. Please let me know if you can't hear me anymore because I don't have any water. It's a bit complex. So big data, what is it? When you collect a lot of data, actually you collect some data and later on you'll see why you collected all those data, and you will try to determine a specified purpose. And that is already anti-GDPR, because in the GDPR you have Article 39, which is a data minimization. You only have to collect the data that is needed for the process. And you also have Article 5 and 6 that tell you that you have to get a specified purpose for this data collection. But the core principle of big data is to collect, and maybe later to see. So you can see that this question of big data and GDPR is not the same in the same terms and in the same issues that blockchain and GDPR, but it's always the same. Technology evolves faster than law, and it's our duty to have a public conversation, to talk about that, and to make sure that there are projects, as it has been discussed and presented before, that will comply with certain social values, which is to protect subscribers or to protect data owners. And I will argue that blockchain and GDPR actually follow the same goals, which is to give control over personal information, maybe to give power over our own digital identity. There are a lot of things that are common, and I will strive to tell you that today I see GDPR as an opportunity for blockchain. So the key definitions, so the GDPR, I told you about it. Personal data, this is pretty easy. It's any information relating to an identified or identifiable natural person. And we will see that GDPR only applies when personal data is concerned. And this is really key, because you have a lot of different data that are not personal data. You have a lot of data that do not qualify under that regulation. And it's important, since those are really complex issues, not to mix everything up. Processing so in order for the GDPR to apply, you have to have personal data and you have to process those data. Processing is any kind of operation on those data. It can be storage, it can be transfer, it can be recording. A data controller is the legal qualification of the entity that pretty much only defines and determine the purpose and the means for the processing of personal data. So there is the data controller, and sometimes the data controller works with data processors, which are people who are working under his instructions to process this data. So it's really important to get back to those definitions, because as you will see, the first key question is to understand if blockchain actually processes personal data, and afterwards you can, if there is personal data, you will strive to understand who is the person responsible for the data obligation, for instance, for the data breach notification, for the privacy impact assessments, and that person, that is a data controller or a data processor, might afterwards need to answer to some claim of data subjects. So GDPR, as I told you, only applies to personal data. You have to actually really distinguish personal data from anonymized data. And this is really something that is difficult, because pseudonymized data is part of personal data. So on the one hand, you have personal data plus pseudonymized data, which is within the scope of application of the GDPR. And on the other hand, you have anonymized data. And all the problem is to know that to determine if you have like a way to irreversibly prevent identification. And this is really complex because the state of the art is evolving a lot, and you have a lot of free identification techniques that can link back to an individual. So people often confuse encryption and anonymization, which is not the same thing. And we can take one or two examples to determine if, for instance, a public key is a personal data. So a public key represents a particular user, and that key is encrypted. But it is used to, to make sure that the transaction, if we are typically in a double spending problem, goes to the right person. So you can ask yourself, is this public key, which is encrypted, should be qualified as an anonymized or pseudonymized data? Actually, the public key, since most of the time there has been studies that can show you that it can link back to your IP address, and there has been some court, like the European Court of Justice already tackled this issue, like for the IP address in the Breyer case in 2016, it has been considered as a personal data. So since it can single out an individual, even though it doesn't know its direct identification, a public key can be qualified as a personal data. So you have a tremendous challenge that will be how to make sure that public keys would be deemed anonymized. So that could be for the tech crowd here a problem to tackle. You can take another example about hashing and all the technology that has been considered by the Working Party 29, which is the let's say the organization that integrates all the data authority, the CNIL in France, the ICO, which is which has the same name as the initial coin offering in the UK. The hashing is a technique of pseudonymization for the WP29. So you can see that if it's pseudonymization, then it will be deemed as a personal data. Those were only like two specific examples, but after that you can have any kind of data, and the key question we have tonight is is the data would be, because there was a lot of discussion, should it be stored on-chain or off-chain? So if you have something that is stored off-chain, that would be considerably different than if it's stored on-chain. Because if it's stored off-chain, a lot of data subjects claims might be able to be we will be able to reply to those claims. And if it's on-chain, since by nature the essence of the blockchain is to make immutable content, you cannot be able to update the data that is stored on this blockchain. So who holds responsibility? I have to say that GDPR, I think the CNIL, the French data authority, is currently working on it from what I learned. So there might be an opinion that will be published in the coming month. But I think it's still a really prospective subject, and it's really challenging because the GDPR, it states that now the technology that will be developed should be privacy by design and by nature. So typically, this issue, blockchain and GDPR, will be a compliant issue, but moreover, it will be like an issue on which we should have a real interdisciplinary approach. Because if you are only working with people who are tech savvy and that really they code in Solidity or whatever, the smart contracts in the blockchain, if they are really experts as far as tech is concerned, that won't be enough, because you would have to code and to develop technology that will be privacy by design and by default, and that is really important. There are some legal issue that I think won't be solved or answered in the short future, because, for instance, in the General Data Protection Regulation, you have to identify the person, as I told you in the first part of the presentation, that is that might be qualified as the data controller or the data processor. But since the blockchain works as a node, with various nodes, and that there are various stakeholders. We talked about miners that give computing powers. We talked about different people who might have developed the initial protocol, people which would develop DApp above and smart contract above all those protocols. So there are different stakeholders, and it's really difficult to understand if everyone on this in this ecosystem will be qualified as controller, processor, or maybe both. And that also depends of the blockchain technology you're using. If you have a private blockchain, it's a consortium of people that is limited, and it's really easier to identify the data controller. If you're in a public blockchain, I think that's a real challenge, and it's a bit like some legal questions we had previously with the internet, that there might not be possible to identify a specified controller of all those protocols. So I will try not to be too long, because I see it's late, and the thing I'd like to really emphasize about is also data transfer, because you have to understand that the GDPR applies to the EU, and you have an Article 3 in the regulation that has also some extra-territorial application. So any entity that is monitoring someone in the EU, or any entity that is offering some goods or services to someone within the EU, will be the GDPR will apply to this entity. So for instance, for an ICO, since you are offering some tokens, if you, as you described, if you direct your offer to some people within the EU, this GDPR, even though you're an entity based in the US or in China, it will be applied to you. And the GDPR provides for some strict rules about, it's the same that the rules that were already in the directive of the 95 directive, but it provides that if you want to transfer some data to a country outside of the EU, you have to present some adequate level of protection. And those level of protection are not the same everywhere in the world. And since the blockchain is by nature a decentralized protocol and a set of technology that promotes decentralization, that's going to be really tough to handle. So the subject you might all have heard about might be linked to rights to be forgotten or rights to erasure. Since by nature the blockchain is immutable, imagine I'm single, tomorrow I'm married, and after tomorrow I'm divorced. You can update the blockchain to make sure that this content, this information about my civil status is upgraded. But the first information, imagine I just got divorced today, and the fact that I previously had a wedding, that will still be somewhere in a block. So imagine in 29 years or like I don't know, in some point in the future, I want to claim my right to erasure, or if I had some bankruptcy problem, I don't want this information to be accessible anymore. If and only if the data is stored on chain, that would be that won't be GDPR compliant. So there are a lot of scholars and people who are thinking about this issue, and they are trying to see how we can promote a way to store personal data that would be off-chain, and the only information that would be on-chain is the hash key that would link to this outside database. And there are also another problem if you store data on-chain, is that you will never be compliant with the limited storage of data, which is by nature something that you should be willing to comply in if you are GDPR compliant. So here is the question about storing data off-chain. The problem if you store data off-chain, that's why it's not also perfect today, is that you still have a lot of cyber attack issue, and you lose all the potential specificities of the blockchain, which is by nature more robust, and so that's a trade-off that is not easy to make, but we'll see how things evolve in concerning that issue. I will be glad to continue the conversation afterward, but I'll make sure that I give you just the main problems that are present in that subject. So you have another way, which would be to say, like, I'm going to destroy the private key, and if I throw away the private key, the data will be on the blockchain, but it will be unreadable, and some people claim this offer a solution that would guarantee a high level of protection as privacy is concerned. I'm not that convinced personally, because but it's an ongoing process, so it's always good to throw ideas and to discuss them. But I think there has already been some scholars that have shown why this destruction of cryptographic private key won't constitute a reasonable way to prove that the data is not accessible. Again, the state of the art will always change, and you will always have different re-identification techniques. And that's my last thought. I think, and I read a lot of, I mean, like, I'm doing a lot of GDPR on a daily basis, and I'm discovering, as all of the people in this audience, blockchain every day, and it's really a complex issue. And I think there's one particular issue that nobody really tackled yet, and so this is my opening thought for all of you guys. There's a really interesting article in the GDPR, which is Article 22, and it's linked to automated individual decision making. Pretty much you have Article 22 number 1 that tells you that this is prohibited, and you have the paragraph 2 that says that if this is necessary for entering into a contract, or if it is authorized by a union member state law, or if a data subject gave you the explicit consent, you could use those automated individual decision making. But it's pretty interesting when you think about smart contract, because today smart contract has not been recognized as an agreement legally, and we're not sure how to make to be 100% confident that someone gave an explicit consent. And so I think this might be a theoretical problem for certain people, but I think it's actually a really important one to tackle, because a lot of smart contracts are going to make automated decision making, and when you read the definition, it will for sure produce legal effects or significantly affects anyone here in this audience. Thank you very much.
Any question?
So on that last point, Adrien, wouldn't deploying a contract be understood legally as not exercising that right? I mean, why? And by the way, I'm talking about Article 22. Sorry, which you just mentioned. So
what's the?
So it doesn't seem to be so specific about when I'm in a position to exercise this right not to be processed. But it seems, so when is it? Is it at the inception of a contract, or is it any time? Because it seems to me like if between consenting adults I decide to deploy a contract, and I'm not even talking about the problem that is to relate the address of the contract and me as a subject, whether I'm a data subject, I don't know. But anyway, it seems to me, naively, that if I enter into this kind of automated contract agreement, then it seems to me that it's like a statement that Article 22 doesn't apply to me with respect to this particular process. What would you say?
I don't know if it's the hour, but I think it's a complex question. Basically, what you're asking is, this situation is not applicable at all.
No. I'm thinking Article 22 cannot be just what you showed, right?
No.
There should be a provision that that tells people they are not allowed to exercise that right anymore, because they've given up on that right. No.
May I? Yeah, sure.
Well, I actually don't completely agree with you on Article 22. Even if a smart contract, you can discuss if it's a contract, there's still the word contract. So even if you have an off-chain agreement, you have a contract. And one of the exemptions of Article 22 is a contract. So if you do profiling because it's necessary in the execution of a contract, you don't have a problem with Article 22.
Exactly, and I agree with that, but smart contracts are yet not recognized, are legal binding agreements by any court. And this is my point. I'm saying.
But I mean, an agreement is. I consent to something, and it's not. It's not like a regulated entity.
Yeah, but if you go to court on a weekly basis, you can see that the main question is to prove your claim. And if you have no way to prove that this is an agreement, a valid agreement, and this get back to a lot of questions about what is the value of a smart contract, or how can I, bring the proof of what I'm saying. I'm not saying this exemption won't apply. I'm saying it's an open debate. I'm saying that it goes back. Yeah, you can prove it. Today, there is no way you can prove it. And I'm saying it can be a theoretical question. It can be also a huge question, because if there is no way to show that in court a smart contract is a valid agreement binding by two or more parties, you're stuck.
Yeah, you have to prove that there has been an exchange of consent.
Yeah, and that's a huge challenge.
Yeah.
In court.
I
mean, like, the validity of blockchain technologies in court. This is an open thought. I'm not saying it's. I'm just saying that everything is going to be automated, and there's a lot of debate that's going to be linked to autonomous systems and the validity and explicit like the execution of an agreement or explicit consent.
Well, may I ask a question, just to pick your thoughts? My biggest problem was, for me, GDPR is completely incompatible with blockchain, and there is no way ever you're going to render that compatible. But anyway, we would need a new text that is adapted to this environment and that would ensure privacy, because there are technological means to ensure some kind of privacy, but they would not be GDPR compliant given the definition the G29 gives on encryption, on hashing, which is all pseudonymous, and so whatever you do. And today we heard about quantum computing, so even if you cannot identify it, a quantum computer can break it all down. So how you can turn it every way you want. I don't see how it's ever going to be compatible. But my point is, who is the data controller? If I transact on the Bitcoin blockchain, okay? So the data controller should be who knows the purpose and the means.
Yeah.
The only person who knows why he or she is contracting is me, right? So if I am the data controller, then there are two consequences. First, I don't see how I enforce my rights against myself, because I would be the debtor of the rights. I would be the liable person. And secondly, you might argue that the exemption of private use applies. If I am using it only for purely private means. And as soon as I do a professional operation, I don't see how I cannot become the data controller. And then I don't see how the whole mechanism of the GDPR should apply.
It's so it was twofold. I think the second point you raised is really interesting, and I think it points the shortcoming or like the dead end of that aspect of the regulation. But as I started the presentation, there are a lot of other dead ends for a numerous amount of technologies. So it's not like, this is why I want to put things into perspective, because GDPR does not comply, like that big data does not comply with GDPR, and AI neither. But the thing is, we have to work, we have to do a lot of stuff, and GDPR took, just so that people in this audience know, 5 years of intense lobbying to be enacted. It was proposed on January 2002, the 22 January of 2012, and it was enacted in April 2016, so it's 5 years in Brussels with a lot of lobbying, and it's a long time. So we won't just like wait for the next GDPR or similar text to be enacted. So and I think there are a lot of things that won't be tackled by law. But so this is why we also have data authority that publish, as you mentioned, the Working Party 29 opinion on specific issues, and I think it's an ongoing process.
Okay, so maybe it's a question for panelists, but I think that there is more than in cryptos than what you think. So I'm a researcher in cryptography, and there are very fancy and modern problems in crypto, like homomorphic encryption, multi-party computation, but even more important is zero knowledge, and I'm surprised to hear a talk about privacy without hearing the word zero knowledge. So maybe you know about zero cache.
Yeah, sure.
So this means you can have perfect privacy on the blockchain.
Exactly.
What?
It's
there are means to ensure privacy on the blockchain, technological means. The bottom line, the point is, GDPR was adopted with the thought of a centralized economy. Someone is having control over something. The blockchain is not that at all. And even if you have something that technically ensures you some privacy, ring signatures, S-snarks, whatever, Z-snarks, hashing, crypto, it is not necessarily GDPR compliant.
But maybe it doesn't need, because it's private, so.
No, but that was
technology does not require a law in that case, because it's private. So
the reason why I
okay.
didn't talk about zero, all those like more complex technology I just like linked to public key and hash just to begin with, is to show that even those basic examples show some kind of like raise issues or show some incompatibility. But yes, of course there are ways to interrogate the content without knowing it. I agree with you, and I think this is part of the ongoing process, and I think that we won't be obliged to have it encoded within the law to make sure that like research and business still like move on, because if not, again, it'll take 5 years.
Yeah, just to continue on that last question, it's true now we have the technological means to have a lot more privacy with all these zero knowledge proofs are an example of that. But on the other hand, I'm not sure the regulation authorities would love it if we were all abandoning Bitcoin or blockchains that do have some traceability built into them by default and started transacting only with Zcash, say. So something with no traceability at all that might preserve our privacy very well, although it might not be GDPR compliant. That's a bit beyond me. I don't know. But would they love it? I'm not sure either. So we're kind of, it's a bit as if we were in a catch-22 situation, right? I mean, it's.
I think you're right. Encryption is a really key democratic issue, and it hasn't been completely tackled. When you come to think about it, it's historically linked to the military debate. It was seen as a weaponization or stuff like that. You have a lot of instance as Apple versus FBI in the US or Telegram versus FSB to know if encryption should be, seen as a human right. Like there are a lot of questions, and I think this is like a perspective, but still a really actual matter. But I agree with you that the zero proof knowledge and all those techniques, and that's why again interdisciplinary approach of the subject are key, because it won't be like all about tech or all about legality.
One last remark? Okay.
So you could have privacy and governance compliance. So, for instance, author of Zcash, they made a second papers, and they say you can have zero knowledge with regulations. So this means when you have zero knowledge, you have proofs that the transaction is valid. So this proof says nothing about the valid transaction, but it says it is valid. So the notion of valid, you can have rules, like to say you can tax them, you can put the maximum cost on the transaction and so on. So you can have rules, okay? So everyone can be anonymous and so on, but you can enforce rules. You could make a law compliant Zcash.
Okay, thank you so much, Adrien. So it's already almost 7. So I think we have a cocktail waiting for us upstairs. But before that, I would like to thank all the participants who have been with us all day. I would like to thank all the speakers who have all of them been so fascinating and stimulating. And I would like to say a great thank you to Vincent DANOS, who has been our host today at the ENS, and who has been working very hard over the past few days to make this workshop possible. And also Alexis, COLLOMB, but I think you already mentioned that in the morning, since it's the chair that Alexis actually co-chairs with Primavera de FILIPPI that has been our support for the workshop. And if you want to add a few words, Alexis.
No, just thank you very much to you and to Vincent for organizing such a great day. So and the last word would be, I hope that there will be many of those actually in the months to come, and I'm sure there will be actually. Thank you.